think we'll get started. If anybody else shows up late, well, they showed up late. They can just barge through that door. Morning. I'm Jim Pethokoukis of the American Enterprise Institute, and this fantastic event you've chosen to attend, watch online, or view on C-SPAN is Should We Reform Section 230. I'd like to start things off with an interpretive reading of Section 230 of the 1996 Communications Decency Act. It is not a long section. It is brief but important, and it states as follows. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Now, for more than 20 years, since the birth of the internet age as we know it, Section 230 has provided websites with immunity from liability for what their users post. The Electronic Frontier Foundation describes the importance of Section 230 this way. This legal and policy framework has allowed for YouTube users to upload their own videos, Amazon and Yelp to offer countless user reviews, Craigslist to host classified ads, and Facebook and Twitter to offer social networking to billions of internet users. Given the sheer size of user-generated websites, it would be impossible and infeasible for online intermediaries to prevent objectionable content from cropping up on their site. In short, Section 230 is perhaps the most influential law to protect the kind of innovation that has allowed the internet to thrive since 1996. And yet, over the past few years, Section 230 has faced heightened criticism from both the left and the right. Many critics on the left argue that social media giants enjoy special protection without any responsibility. They allow speech without worrying about its consequences, resulting in harassment and the increased prevalence of hate speech online. Then other critics on the right have argued that these companies have gone too far in policing for these vices, or at least have gone too far in policing conservative voices, and they've enacted a biased double standard when it comes to content moderation. In light of these criticisms, and in line with the bipartisan political backlash against big tech, we've seen calls to reform Section 230. And it is these calls and this debate that we're going to discuss today. And I often use the phrase all-star panel. This time I mean it especially. This is an all-star panel. Immediately to my right is Danielle Citron, author of the 2014 book, Hate Crimes in Cyberspace. She's also a professor of law at Boston University School of Law, where she teaches rights about privacy and free speech. Next to Danielle is Jim Harper, a visiting fellow at AEI, where he focuses on privacy issues and select legal and constitutional law issues. And over in the end there is Jeff Kosseff, assistant professor of cybersecurity law at the Naval Academy's Cyber Science Department and author of the recently released book, The 26 Words That Created the Internet, also a podcast guest on the AEI Political Economy podcast. Welcome all. Let me start with Jeff. What do we know for sure, or we know reasonably for sure, was the intent behind Section 230? Why did legislators feel the need to bring it into being?
So there were two main reasons when you look at the legislative history and when you talk with the people who were involved in drafting and advocating for Section 230. The first was there was really a concern at the time about, which it's kind of quaint, legal pornography that was available to children online. That was the biggest concern about the internet at the time. And there was a series of court rulings under the common law and the First Amendment, which basically stood for the proposition that if you did not moderate content, you could actually increase your chances of being protected from liability for all user content. But if you started to moderate, then you could expose yourself to liability for defamation and other types of harm. So there was really a concern then that this system was giving an incentive for platforms not to moderate. So that was one driver of Section 230. The other was, you have to think about the time. It was 1995. The modern internet was really at its infancy, and Congress wanted to get regulation and lawsuits out of the way of the development of this new technology. So between those two reasons, those were really the driving forces behind Section 230.
Right. So is there I sense, and again, everyone can sort of jump in as you don't need me to call on you. I probably should have mentioned that earlier. There seems to be confusion about that original intent. I think what you've tried to dispel with your book and other appearances. What is the confusion? That seems fairly straightforward. And I know that you've talked to people involved, staffers and legislators. There seems to be confusion about that original intent.
Do we have all day? There's a lot of confusion.
In fact, we do not.
So, and I'll say I'm only speaking on my own behalf.
There's a lot of myths around this. We don't have to hit them all, but just in that sort of narrower issue of what was the point of this to begin with?
Okay, so speaking just on my own behalf, not on the behalf of DOD or the Navy.
Sorry, I should have mentioned that.
I should say that. There's a lot of confusion. I'd say the biggest bit of confusion right now is that Section 230 is conditioned on neutrality, that it only applies to neutral platforms, whatever those might be, rather than publishers. The point of Section 230 was to eliminate that distinction and allow platforms, or really online services at the time, to exercise discretion, figure out what their users should or should not be exposed to, and not face the liability. So I would say that's probably the biggest.
But again, the issues that were sort of foremost at the time were issues, again, about pornography and defamation. They weren't so much about politics and political views, were they?
Not at the time. I mean, there was a statement in the findings for the bill that said something along the lines of wanting to foster political discourse. So, I mean, there was a recognition that there would be free speech online. So to that extent there was, but there was no conditioning of neutrality on Section 230's protections.
But I think we're forgetting the title of Section 230C, which is protecting. The idea was it would apply to Good Samaritans who were protecting against, who were blocking and filtering offensive speech. So absolutely, the idea was to incentivize self-monitoring, to provide protection for those who were blocking and filtering offensive speech, which is completely legally protected speech. But we wanted to incentivize.
But that word offensive,
that is in the subtitle of the book.
But what did people think they meant by offensive back then?
Well, it's also
certainly
in the...
very different perhaps now.
So you quoted
surely.
C1, which are the 26 words.
Right.
C2 allows good faith efforts to block access to a list of types of content, including other objectionable content.
Harassment,
so, yeah,
right? They
so,
had
I mean,
harassment in mind, right?
But yeah, exactly. I mean, Congress wanted to give a very wide range of discretion to these platforms to feel free to block content and not be exposed to liability.
Okay. And just kind of maybe a brief legal point. Were they not already protected under the First Amendment? I think I hear that get a lot. What about the First Amendment? Doesn't that protect these companies?
Well,
why do they need this sort of extra protection?
So that was the problem that led to Section 230 in the first place, is that there's a lot of different First Amendment protections, but one is for distributors of content that others create. And the rule there is if you're a distributor, you can only be liable for other people's content if you either knew or had reason to know. But the problem became that the court started saying if you start to moderate, you don't even receive that protection and you become strictly liable, just like a newspaper would be for its letters to the editor. Right. And that was the weird system that was created by the First Amendment.
And it wasn't so much First Amendment as it was common law development.
Yeah.
That is the courts were looking at this new medium and coming out in different places on whether a platform provider was a publisher or was a speaker. And in my opinion, the law kind of jumped ahead to what I think was the right result. But it's unfortunate that we got there through legislation rather than through continued common law development. Mm-hmm. I think it would have taken years, but then again, years later, we're here talking about it. Yep. If the rule had been generated from the bottom up through experience, I think it might have been a stronger rule and a better understood rule, and one that's based more deeply in practice, rather than getting this over-the-top legislation, which I think was pretty good, but maybe not perfect. Right. So we'll see.
And given that, and just a little bit on the history, how controversial was it, or did this thing just kind of slip through and classic case where people kind of didn't understand all the consequences that would sort of flow out from it, or was there much real debate at some point in the process?
So there was a little bit of floor discussion. There was no real opposition on the floor. It passed. It was attached to the telecom bill in a 420-4 vote because this was part of the much broader overhaul of telecom laws in 1996. And Section 230 was really seen as an alternative to the Communications Decency Act, which was both of those ended up being put in the Telecom Act. The Communications Decency Act imposed all sorts of prohibitions for speech that was indecent, and the Supreme Court struck that down. So Section 230 received barely any media coverage at the time, and when it did receive media coverage, there was no coverage of the fact that it was going to shield platforms from liability for most types of user content. So it was really an afterthought at the time.
Yeah, I'm curious. So we have this law that shields internet companies, big platforms. How does it work in Western Europe, for instance? Do they have their own version of Section 230?
So they have rules, and I mean, Europe has a number of different rules. I write about one of the cases in the book, but it varies a little bit, and it gets into the classification, whether it's a conduit or some other types of service. But there are some cases where the courts have said, not only do you have to take down user content if you get a notice complaining about it, you also might have a duty to actively patrol for user content that might violate not just defamation laws, but hate speech laws and things like that. So it's much more restrictive in really most other jurisdictions than it is in the United States. We're very unique in that respect.
Maybe unintentionally, Jim, you said it protects big platforms, but it also protects small
Everyone,
platforms. And my thinking on 230 is animated by operating a very small platform for a number of years. I ran a site called WashingtonWatch.com, which was a government transparency site. Don't go look there now. There's nothing but broken dreams. And when Web 2.0 came along, I changed Washington Watch to Web 2.0 style. You'll remember that phraseology. That's when people actually started to be able to comment and vote and add their own material. So we had a comment section. I had a little success. There was a bill to extend welfare benefits, unemployment benefits, and it had something like 200,000 comments. And I was the only guy in my spare time watching what was going on the site. And of course, there were people behaving horribly to try to undermine the conversation. There were people who were telling me that someone else was using their name, and I was called on to moderate this situation. I wasn't consciously using Section 230. I was just trying to do my very best to create a good environment. But it's extraordinary the lengths that people will go to, in my case, undermine the site because they thought I was in favor of this legislation when in fact it was a neutral platform, or meant to be. Unfortunately, the internet, for all its blessings, allows people to be truly wicked from behind that anonymity. And they will take every effort to upset each other. They'll take every effort to undercut the platform itself. So it's an area that's fraught. And 230 is a very important protection given what people will do.
But it's not just that to make them upset, right? People will use network tools to destroy people's lives, to post nude photos of them, to ensure that they can't get a date, keep their jobs, get a new one. They will, threaten death and rape, right? They post defamatory information that one can never sort of respond to, which is, I'm not a prostitute, I don't have a sexually transmitted infection, right? So that the kind of mischief that we've seen isn't just like things that hurt people's feelings. It's not just offensive speech. It is speech that we would say isn't even legally protected, that we can criminalize and ensure liability for. And there are sites that make a business out of hosting non-consensual pornography, right? And they get to, with glee say, I can encourage people to post others' nude photos. Sue me, good luck. I'm immune from liability. And people's lives are ruined. So I think it's just important to note that, the mischief isn't, and I'm with you because I help run Concurring Opinions, and so we were busy filtering, crazy comments too, right, on our sort of legal theory blog. But it's far more than that, right? Like any wonderful tools for great things and also for ill, we see a whole lot of illegality and destruction of people's lives.
And indeed, so we had this piece of legislation, not particularly controversial, now very controversial, and as I alluded in my remarks, for different reasons from different perspectives, But just 1 second before we get to that, because Jim, you mentioned that perhaps some of these protections could have evolved sort of more organically rather than legislation. But given how the internet has sort of developed, if that Section 230 had not happened, what might the internet look like today, and how might it have evolved without it? Since now we're so interested in changing it and reforming it, if we didn't have it right now, what does the internet look like?
You have an argument on that, I think. It's the
Yeah,
title of your book.
yeah. So I think I'm a little skeptical that the common law would have developed to the extent of the protection that 230 provides. I think some of the early court cases were not very well reasoned or well decided that really imposed significant liability, but I don't think that the really broad protection that Section 230 provides for third-party content would have been the same under common law. I think there probably would be more of a notice and takedown type system where if you get notification of potentially illegal content, your choice is either take it down or you have to stand in the shoes of the person who posted it and then defend it, which most rational platforms are not going to want to do because they don't want to litigate all these defamation cases. So I think you wouldn't see necessarily the same extent of social media, of Yelp, all these services that really not coincidentally are based in the United States.
I mean, people often will wonder why. Where are all these sort of social media giants in Europe? I mean, do you think 230 is a big reason why we have them and they don't?
Very much so. I mean, I think that they were able to develop in the way that they currently are because of Section 230. We would probably have different types of services, but they wouldn't have the same sort of rules that they have right now without Section 230.
There are big social media companies like in China, but it's complete censorship and control. So it's not like we wouldn't have these companies. They would just look right.
And people would just be posting dog videos and their kids.
It would be pretty benign.
Right.
I think it's right that we got the big social media industry we did because of 230.
Yeah.
Is that right or wrong? You could also conceive of 230 as a sort of subsidy.
Absolutely.
A liability-free subsidy. The same way the corporate form of organization is a subsidy to businesses that comes at a cost to consumers in some degree because there's a little bit less liability for corporations. A little bit less liability for social media platforms meant we have a huge social media industry. It came at a cost, though, in victimization of select people in some cases that are very sympathetic. So,
and some of those negative externalities include speech. So when you're targeted with harassment online, you are silenced so often, and we forget that those negative externalities aren't just lost jobs and potential physical violence, but also speech. Yeah.
And sort of the externality. I mean, it seems like this is suddenly a very controversial topic right now. We're talking about different ways to regulate big tech, but those sort of externalities and sort of victims, they were there really from the very beginning. And I know in the book you read, there's several interesting cases of people who are actually hurt, extremely sympathetic stories, but yet were there any calls back then to listen, this is generating victims, we need to do something, or did it pretty much continue to its present state, ignored by policymakers?
I think for the first decade it was not really a hot button issue, and even into its second decade it wasn't. And there were some tough cases.
But what about Senator Lieberman? The idea that he wanted to pressure Google and YouTube to take down terrorist videos. This is 2004?
Yeah.
And that just gets ignored, right?
Yeah.
I mean, so there weren't. Was that sui generis, Jeff? Because I only knew about those efforts at the time.
I guess what I'm saying is to the public attention to it was not nearly the same. Mm-hmm. And there were really tough cases in the beginning. So there's a lot of people who argue, well, there have only been difficult cases in the past few years. The second case ever litigated under Section 230 is a case called Doe versus AOL, where a mother sued AOL because there was child pornography with her teenage son in it, that AOL was being marketed in an AOL chat room, and she kept contacting AOL and they wouldn't prevent it. That's a difficult case, and so it's not just like there were only easy defamation cases in the early stages. There were tough cases all the way from the early days of Section 230. So
even though it's child porn, so that it falls outside of 230, federal criminal law doesn't
Yeah.
enjoy that immunity.
But she
Yeah.
she was suing for negligence. So
okay. I got you. No,
yes.
but important to clarify for
Yes.
everybody.
Another important dimension of the problem is
Yeah.
the changing technology over time. In the early days of CDA 230, maybe you had manual processes entirely. Nowadays, a thing like child porn, you can kind of automate tracking, and those systems are in place where you get a hash of known child porn files, and you can review anything. There's a case in the 10th Circuit where AOL found child porn and delivered it to NCMEC, which was a government actor for those purposes. It's called Ackerman. Justice Gorsuch wrote the opinion. It's a very good and interesting opinion on its own. But automated review for things that are self-evidently criminal seems like an area where you might be able to hold platforms liable. Self-evident, though, is important, I think, because if you're taking defamation or stalking or something like that, it's really hard for a person coming in for the first time to a conversation to figure out whether someone is defaming another. What's the reality of it? I did have a person contact me and say, someone else is using my name. I've written a book on identity, and I know that names, even rare ones, are repeated many times around the world. So I was dubious of the argument, and I couldn't bring myself to take something down as an identity fraud, if you will, because the same name was being used as another person out there in the world. I don't think that the people who are faced with these decisions, like myriad different kinds of problems and stories coming to them in the bowels of the social media organizations, are going to be able to negotiate and navigate those kinds of determinations very readily. So self-evident wrong,
Automation
you
is
might
for
have a
lots of these
liability
problems.
appropriately attached,
Totally.
but things that aren't self-evidently wrong, I think you probably shouldn't have liability for those platforms.
But so these cases would come up and there'd be these stories, but generally this was sort of left alone, it sounds like, by legislators. It's sort of not anymore. Is it the case just that you have these sort of big platform companies which are been in the news, and I mean why now? Why is it now this incredibly controversial issue? Was there a triggering event, or is it just that they're now so big and intrusive in our lives, we're just taking a closer look at all these companies and what regulations and laws apply to them?
I think it's like a couple of things coming together all at once. I feel like we could all probably take each thread and bring it together, right?
I mean, people don't like the tech companies as much
Yeah,
as they
here
used
we
to. I
are.
think that's not a
Cambridge
controversial.
Analytica.
Yeah.
Right.
Right, Mark Zuckerberg
Probably
is
biggie, yeah.
testifying, Dorsey, Sandberg, they're getting pummeled. It's a wonderful opportunity for every senator and congressperson to sort of hop on the bandwagon and saying, you're the Antichrist, forgive me if I transgressed religious norms. You bear full responsibility of all mischief online.
Right.
And it was sort of an easy pot shot. And then, so what else can we throw in the mix? We have Cambridge Analytica and the attack on our country from Russia and disinformation, and then therefore blaming the platforms for not doing anything about it when they were caught unawares and off guard, right? The advent of deep fakes. We have, I don't want to take up the thunder. I feel like we all want to pitch in something.
I mean, I would also say that one thing I've observed is that the traditional news media perhaps is not very happy with the business models of some of the large platforms because of what they've,
It certainly seems like one criticism is that this
Absolutely.
enables those very business models, and that it's not just about moderating and shielding these companies, but it's a key part of why why these companies are worth $500 billion or $1 trillion.
Yeah.
And they're not nascent. They are engaged in surveillance that earns them tremendous amount of money, right? And they are stealing the business of news companies. Well, right, Jeff, is what you're saying.
Yeah, or that's
Or
definitely-
in the mind of big media.
One
Right.
problem, which is familiar to students of regulation, is that if you were to deeply undercut Section 230 protections, the biggies would be able to navigate the new law,
Right.
and the little competitors that are coming up to try to challenge them would not be able to navigate the new law cost effectively. And so like regulation typically does, it would lock in the status quo in the marketplace. And so Facebook's natural decline would be delayed, if not foreclosed, by doing away with 230 or deeply undercutting the protections of 230. It's there as much for the small competitors as it is for the big platforms.
I have an approach that wouldn't do that, but we can talk about that later, about what that might
Sure.
be that would treat the big platforms and the smaller platforms differently. We don't have to get there yet, but
And I would also say that the larger platforms have lacked some transparency over the years. They've started to change, but I mean, it was often like a black box to figure out what's going on in there. How are
seems
they
to me that's
making these
particularly a
decisions?
complaint
Yeah.
among conservatives who think that that these companies are biased against them, and they don't see, well, I don't see why that person's being taken down or demonetized or shadow banned, and why not that person? And if this has happened to me, do I call an 800 number? What do I do? I think transparency and also they don't understand the process. But I meant when I went on, of course, Twitter to discuss this, there was a statement that Section 230, it's terrible. Basically, what it does, it enables hate. It enables hate and harassment.
But it also
So
enables great things too, right? So
you've written about many of these problems.
I have, and that's right, that the free pass, that if we don't
In your
create-
fine 2014 book, again,
yes, and
hate crimes in cyberspace.
Oh, thank you so much. and in work that I've done with Ben Wittes in the Fordham Law Review in 2017, we sort of propose a way in which we can fix the statute without doing too much violence to all the great things that it does, right? Because on the one hand, Section 230 provides this safe harbor, which isn't conditioned on any good behavior or good faith when it comes to under-filtering. When it comes to over-filtering, we condition that on good faith. Right, but for under-filtering, the part of the statute you read aloud is 230C1. It doesn't condition that immunity on any good behavior, right? It just says you have this immunity. We're not going to treat you as the publisher or speaker of somebody else's content. And what that has done and been interpreted really broadly to mean that even websites that encourage non-consensual pornography, that entire business model is abuse, essentially, right? Sites that cater in deepfake sex videos, they get to enjoy this immunity from liability, even though they are not engaged in any kind of content moderation, and in fact are encouraging it and making money off of it. And so, can I talk about my proposal?
Not yet.
Not yet. No, that's what I'm thinking.
This is like a
Jim, I wanna make sure.
stay tuned moment.
Yeah.
So no one tunes out
Isn't that
because the big
censorship?
proposals are coming. But I mean, I think people.
I don't want to get rid of it, needless to say.
Right.
I think Section 230 has been incredibly important. It was incredibly important for these early years in which we do have the Yelps, we do have Facebooks, we do have incredibly pro-social activity online. It is now.
That's not what you're hearing, though. I mean,
Right.
it seems like
Yeah.
all these positive things that most of the stories that you hear
We have
are about.
Wikipedia, let's say. That's pretty damn pro-social, right?
But you hear about, again, whether it's actual harassment,
Right.
Whether it's hate speech, whether it's people being, with people, uploading, really, violent videos, that these companies have been given, a lot of power, and they've gotten very big. They show absolutely no responsibility. That's the criticism. There's no, the classic, with great power comes great responsibility.
Right. No, it's
Where's
power
the
without responsibility.
Yes.
But what's interesting is that where were those people when the folks I was writing about who were victims of cyberstalking, non-consensual pornography, where were they? Companies were actually, that is all these politicians that are now so worried about hate and harassment, they don't really care, let's be honest. All these years that I've been writing about it, no one says a word, and it's only when it's sort of like when it's your ox that's being gored that they care about it, when they think, oh, political speech is being marginalized, which empirically speaking I'm doubting is true. But the companies actually, the largest platforms, have been working on these issues, and I've been working with them, Facebook, Twitter, Microsoft, for years, right? They haven't done a terrific job. They've been trying. They've gotten better at it as it's been bad for business. Why does Twitter take a stand against stalking and threats and non-consensual pornography in 2014? We had Gamergate. And advertisers started pulling their money. Same with Facebook. If it's bad for business, they've long tried. They haven't done a great job, but they're making efforts.
These are not new companies. I mean,
No,
they've
right.
been around for a while, and I think a lot of people would think they would have better policies, more aggressive policies at this point, and that speaking not caring that maybe the politicians really didn't care, but that maybe they just didn't really care that much.
Oh yeah, I mean it's like a will.
Until it became really a big issue in the public consciousness.
One of the things that I think is important to highlight is that a lot of the worst wrongdoing that happens online has a wrongdoer who's on the other side of the platform doing the wrong thing. You take something like revenge porn or something like
They're
that.
perpetrators.
You know exactly who the perpetrator is, and they're the one who's the actual wrongdoer. Maybe you can divide it up in percentage terms, but if they hadn't done what they did, the platform wouldn't have any of that material on it. There's a case that I think got dealt with in the Second Circuit recently, where it's unclear that they actually sought. This is the Grindr case.
Yeah,
You
yeah.
probably know it better
Yep,
than I do.
of course.
It's unclear that they did very much to try to stop the actual bad actor.
And Grindr did literally nothing and designed their site so they made it impossible.
Very
so
well.
they said
Very well
to
and good.
find his
But-
perpetrator.
but-
Can we maybe spend 30 seconds saying what that issue is, what that case was?
So Grindr is a hookup site, and a jilted ex-lover adopted the identity of the other and invited, I think, something like thousands of men to
1,000
come
plus men to his house.
to his house,
Because he
offering-
posted fake
offering
ads
sex. Yeah.
saying that he was interested in anal rape. And
Really,
provided
really
the
awful
victim's
behavior.
home address. And so over 1,000 men came to this man's house because
Really,
they-
really awful behavior
Right.
on the part of a known individual.
But Grindr says we
And
can't.
Grindr
Yeah.
opted not to do anything, but the known individual was I think there was a
Law
protective
enforcement-
order against him.
That's right.
Very little
Was
else.
not enforced, and law enforcement. So
Yeah.
I'm not the lawyer in the case, but I
And I
have
think-
written about the case and know the lawyer well,
Sure,
who
sure.
represents
Yeah,
the victim.
And I think
law
law enforcement
enforcement
failed to
does
act.
nothing,
And
right,
I think
in
that's a
Europe.
law enforcement story more than a Grindr story. The attractive defendant, of course, is Grindr and not the probably penniless perpetrator
But I'm
of
not sure we
wrongful
should feel
acts.
so badly for Grindr because Grindr tells Michael Herrick that it has no capacity to identify anyone on their site, and they cannot prevent people from reappearing, which is nonsense. Let's talk about as a technical matter, right?
Ooh, I
Its
think it might be
inability to
sense.
trace IP addresses is a design choice.
Right, but people's ability to avoid IP tracking is pretty readily used. I think if you were required to figure out when and where a person was making fake accounts on your own platform, you'd have a hard time doing it. It would take a lot of resources, and
So
with
this
someone
is-
dedicated to defeating you, you got to put a full-time employee against
But
any
do we feel
individual
this
that's
is
trying to do
fundamentally a
wrongdoing on your site.
230? Do you think it's fundamentally a 230
Oh,
issue?
but it was,
Yeah.
because clients
Where
sues
it's
230.
lacking, yeah, but so where
Right.
230 is not doing the job.
Right. I mean, because I think ultimately, Grindr says, like, we chose not to design our site in a way that would make it at all easy to block people who are doing mischief. And you know what? Twitter, they can block mischief makers. Facebook, it's not that technically difficult. They design their, Jeff, you join me if I'm wrong about this. But, Grindr's business model, they said, would be disturbed by changing the architecture of their site. And I just think that's, given how it's been misused, strikes me as they've created
Yes.
something that's ultra hazardous and they
yes.
walk away and don't
Well,
care.
and
Real quickly, a
Yeah.
lot of us in the privacy community want surveillance to be pretty hard, even for the corporations that run the sites. So it's not necessarily a bad thing
Right.
that there's a platform that makes it hard to figure out who's who. So this is a tough balance to strike, and I'm not sure that
Right.
Grindr was wrong when the actual perpetrator of the wrongdoing was not entirely left alone, but not pursued as readily as the platform.
Well, and I think, so I read the cert petition in the case, which is, I think, going to conference in October at the Supreme Court. I think it probably has the best chance of getting granted of any Section 230 cert petition because it makes a really unique argument about product liability rather than because, I mean, Section 230 is really clear, treating as a publisher or speaker. I think there's a reasonable chance that the Supreme Court would take its first ever Section 230 case. And that's a really big deal because Section 230, we rely on a Fourth Circuit case, which was the first opinion to ever interpret Section 230. And everyone's kind of taken that as how you interpret Section 230. And I think this I think is the biggest challenge that I've seen yet to getting it to the Supreme Court.
So one reason this is sort of in the news are we have sort of more high-profile examples of harassment. We have hate speech online. And there's the companies they've been given this ability to moderate, and they're not moderating. You said that, that you've worked with some of these companies, and do they feel like they're being treated sort of poorly by the media, that they're getting that all their good efforts, and it's just kind of that it's a lot harder than what you think. All these policymakers, they understand the technology, they understand how difficult it is. You just can't come up with a better AI or hire 5,000 more moderators, and the policy solved. They feel like people just don't get the difficulty of the kind of moderating at scale.
Scale is a huge problem, right? So for any given grievance, it's really hard at scale to get it right all the time. But I think there's some recognition that Twitter knows that, and this is just speaking from not confidential information, that up until 2014, it wasn't doing the right thing, right? That it had a very hands-off approach when it came to threats and stalking and non-consensual pornography, and it sort of changed its direction. Facebook has long banned harassment and stalking and bullying, and I would like them to be more transparent. They have incredibly complex rules internally. So inward-facing, they have guidelines that are, it would take days to read all of it, right? But not public-facing. So that while they say they ban hate speech, they don't define hate speech. They say they ban harassment and stalking. Define it for us. Explain to us why you ban it, and give us examples. And tell users why you're banning them and give them a chance to respond. So, are they doing better than since 2014? They are, right? Are they doing a great job? I don't think so, right? I'm on Twitter's Trust and Safety Task Force, and I've been working with Facebook on their non-consensual intimate imagery, and with them for 10 years. But I do it in a way I don't get paid, so that I can be honest with them, and I can talk about it publicly, right? Not based on confidential information, but it's important to. If you don't get paid, then you can be, as an academic, you're free to say, I can criticize you, and you're not doing a perfect job, but by my lights, Facebook and Twitter are virtuous compared to the revenge pornographers, right? So as we think of these things as a scale, bless Twitter and Facebook, Microsoft and Google, and YouTube for at least trying a little bit, right? Because you have sites whose business model is abuse, and who their entire ability to make money is contingent on encouraging users to engage in non-consensual pornography, threats, and defamation.
And I would also just add that moderation is really hard at the scale that they're having to moderate. So we can talk about, what's a hate speech policy for a large platform, but when you're getting this flood of hate speech or other potential violations all the time, and you have contract moderators. I encourage everyone to read. The Verge has had a great series of stories about what the life of social media moderators is like. It's not very
Sarah
good.
Roberts' new book. Let's
Yes,
plug
absolutely.
that behind
Yes.
the scenes.
Yeah.
Always happy to plug my friends' books. Right?
And
yeah.
so, when you have people, I think they make $30,000 a year, and they're being exposed to the worst possible aspects of humanity, having to apply these detailed policies, there are going to be mistakes that are made, even in terms of whether it violates the policy, and there's subjective judgment calls. So there's no easy solution here. Nothing that Congress does or doesn't do is going to solve the problem that we have right now.
And it's not just the United States, right?
Yeah.
The European Union, so I've written a lot about the pressure that EU Commission has brought to bear against the major platforms, bullying them into taking down hate speech within 24 hours, and it leads to sincere and serious censorship creep because their terms of service, they use them globally, right? So if we're seeing censorship creep due to pressure from Europe, it ends up here. So it's not just conversations within the United States. We're seeing pressure come from Europe as well. These companies are global.
And something we sort of touched in the beginning, when I was sort of outlining the problems, is you have people on the right who are absolutely convinced that these platforms are speaking of censorship, censoring political viewpoints that they disagree with. And as part of that argument, they've said, listen, Section 230 was established with the intent that platforms would be neutral, and there's no difference between platforms, and there's a difference between platforms and publishers. When I went on Twitter again tweeting about this, someone said, listen, they have to choose. Are they a platform? Are they a publisher? They need to fulfill their 230 responsibilities. That's one of the myths that sort of. So I guess two questions that all can answer. One, do they think that that especially the big platform companies are suppressing conservative / Republican speech? And sort of two, what about that platform versus publishers distinction?
I mean, I could just answer no, there's not one. But I think to get a little more detailed here, there is not a distinction in Section 230, but this is also a law that Congress passed. So whether there is and whether there should be is a different question.
Certainly.
So I mean, Congress could very easily say that there is going to be a neutrality requirement, and then we can debate the merits of that. And I think that's a debate that we can have. But I think some of the debate has gotten conflated in terms of what Section 230 does say and what some people think it should say.
I'll open the debate on whether there should be neutrality. There's no such thing.
Yeah.
You can't administer a neutrality rule, so don't even try.
Yeah.
Well,
You
again, there
could.
has been
the
some.
telephone, no, like your conduit, so like there's no monitoring.
I mean, you could have no
You could,
moderation
right?
at all.
So yeah,
No?
Yeah.
electric
Just
wires.
asking. Right.
Electric wires are
Right.
neutral. Platforms are not. They have the way they work and the way their users use them, and that's not neutral in any administrable sense.
Well, you were sort of referring perhaps to a piece of legislation by Senator Josh Hawley, Missouri, where the commissioners from the FTC would be appointed. They would have to certify that these platforms were politically neutral. If they wanted to get those Section 230 protections, it would apply, almost I think specifically to the very largest platforms. One, I guess you're sort of indicating already, one, is that a good idea? And if you did think it was a good idea, could you actually do it? Like, how would that actually work if you wanted to certify these platforms as being politically neutral?
You'd have to have a federal speech agency. That concludes my answer.
No, but keep going, right?
It's absurd on its face, given our traditions and our Constitution, to try to have any kind of federal body determine whether a platform or any speaker is neutral and fair. We had a fairness doctrine at the FCC, RIP for a very long time, hopefully. I think that debate is over. That ship has sailed. It's come and gone. Yes, of course, Congress will talk about it like it could happen, but it would die in the courts if it got through the legislature.
Jeff, is it unconstitutional?
I mean, I think it would have to be tested. I think it probably would be. And I also think even beyond the constitutional issue, practically, I mean, the FTC, even with their native advertising, I mean, they're not very comfortable in making editorial judgments on things. So I think there's constitutional issues, practical issues, and there also is a requirement for a supermajority on the FTC. So that would mean that even a minority party could block Section 230 from some of the large platforms if they wanted to. So I think there are a lot of logistical issues as well as the constitutional issues.
But it might be helpful to explain why it's a constitutional issue. It goes back, Jim, to your point about like the First Amendment and who are the First Amendment actors. Whose speech would be controlled by government and compelled? It would be private actors. Platforms are speakers too, right? They're private actors. They're not the government. So they're not First Amendment actors that owe us freedom from regulation. They would argue, we can sort of channel Eugene Volokh, but they would argue that they're speakers, the platforms, and it's their speech, and that they should be free from government regulation. So I just thought it might be worth, this is a teacher and me, sort of circling back to your...
That brings up what I call my woke Facebook scenario, which I think we
Okay.
may have mentioned. One day,
Okay.
Mark Zuckerberg, who at one point, he was touring the country, people were wondering whether he was going to run for president. What if he says one day, listen, I'm very concerned about the direction of this country. So from now on Facebook, you can feel free to post about your family, great funny pictures, what's going on in your lives, and we can post about issues of racism and gender, but no Trump posts. We don't want to hear posts about the Trump agenda. We don't want to hear about that. We're going to be woke Facebook. Is that not a government issue at that point? With this massive platform, so influential in our lives, could change the debate. They may be a private actor. They certainly have a tremendous public role.
They have tremendous power, but they're not a public forum, and they're certainly not
So
a
that would be
company
okay
town.
to have woke Facebook.
Sure, guess what? Go to Gab, go somewhere else,
and there
right?
was
Go to Twitter.
And there was a knitting forum, an online knitting forum that
Yeah.
made that very very
Yeah.
same choice.
Probably
Obviously,
had somewhat
Facebook's-
less than 3 billion.
Yes, exactly.
Right, I'm
exactly.
not sure.
And I think that we had a recent
we
Supreme
can walk
Court
with our
decision
feet.
a few months ago that Justice Kavanaugh wrote, which found that a cable access station did not have the First Amendment requirements. So I think that really gives you an idea of the direction the Supreme Court is going with that.
In fact, I was reading an interview with Senator Hawley, and he said, and I think there were a lot of misperceptions about what Section 230 called for, about that in fact there wasn't some grand bargain decades ago about how these would operate, and I think now, hey, times have changed. When this regulation was instituted, we didn't have these big platforms. The internet was not as big. We did not have these business models. So now it's sort of time for a change. And they're tremendously influential in speech. So I guess maybe that we're getting sort of the reform part of our conversation. But just to be clear, their role in political speech, even though that may have not been sort of the top line issue back in 1996, that's certainly covered in this idea that they can choose to be neutral or not neutral. And it's not just defamation, and it's not just pornography.
Look, Professor Citron said that Facebook is powerful, but I think you'd quickly understand the limits of Facebook's power if Mark Zuckerberg tried to declare it a no-Trump zone or something like that.
100%. Don't you think people are like, you're kidding me? Why?
It would likely play into Trump's hands to have
Yeah.
this kid in
And
Palo
we'd have
Alto
Trump
trying
up.
to play
Like, no? We'd
presidential
have it-
politics.
Totally, we'd have an alternate social media site that would pop up pretty fast.
They're already out there waiting.
Yeah, sure.
You know? So,
Yeah.
so I mean, Congress has these concerns, but I don't think they're real. The capacity to control the country via marionette strings is long believed, but never very well demonstrated.
I think, though, it's certainly, and I get that as I sort of discuss this issue with her on social media or elsewhere, that certainly there are a lot of Republicans and who are absolutely convinced that they see there's 20 Twitter accounts that are suspended by Republicans for every one that might be on the other side. Have there been actual empirical studies or analyses looking at any of these issues?
There's been a lot of anecdotal discussion for a variety of concerns about platforms, which can we talk about potential solutions now? Are we at that?
Yeah,
Okay.
sure.
Yeah, 'cause
So this is probably the most sort of
but should we just
DC-based.
say that it's anecdotes, and if you dig in a bit, it seems completely overblown and untrue. That if I can come up with 10 stories about, Black Lives Matter protesters who are removed from Facebook and Twitter, and so does that make sense? It's like we all have our examples we can trot out. I think empirically speaking, it seems to be pretty false. But let's.
And
I
indeed,
welcome
the audience
the
may
studies.
have questions on this very issue, and we will reserve time, which I should have mentioned earlier, 15 or 20 minutes if people have, and I will even look all the way over on the other side here. They have questions, so sort of if you want to sort of be mentally putting them together. But I'm again to get the issue that I'm wondering if people grasp the difficulty of the content moderation. At the same time, I don't want to let these companies off the hook that they've been doing a fantastic job with content moderation when it's clear that it is a work in progress at best.
I think it's going to always be a work in progress, just given the scale and given the types of problems, given the challenges and pressures from outside the United States. What I would like to see companies do, though, and I think we've seen some of it, at least with the largest actors, is to be constantly thinking and iterating and experimenting, whether it's addressing a deep fake problem by, coming up with technical solutions, which is going to be very hard to do, but with new types of policies and thoughts that if there's pressure on companies to do something and to act reasonably, then they will iterate, they will experiment. There's no one
Do you think there's a
solution.
political space for that iteration? Because when they iterate badly, wrongly,
I do.
It seems
do.
like, at least right now, that the response is ferocious. that they cannot get it right, and there's not like, well, that was an interesting experiment that went wrong. Let's see what they come up with next week.
Right.
I'm not sure that's currently.
Jim, I want to challenge your premise a little bit that
Yeah.
they're not doing
Challenge
that.
away.
They're
They're
not doing
doing
that
it.
good a job.
Oh, yeah.
Because we happily aren't in a position to see what it
Yeah,
would be
we don't
like if they
know.
weren't doing the job they're doing.
Yes.
The articles you referred to earlier, what's the publication, Vice? Or,
Verge.
Verge.
Right.
Read those articles about what
They're
the
doing it.
moderators are seeing
Yeah.
and what they're preventing you all from seeing.
Yeah.
And you have a little bit of respect for what they are doing. It's one of those things. The things we're not seeing are really, really
world
horrible. and
without
might make you,
moderation
might
is
make you
scary.
think that they're doing a better job.
Well,
than it
indeed,
looks
some
like
people
from-
who would criticize these content moderation policies say, let 1,000, let 1,000,000, let 1,000,000,000 flowers bloom. Let's just put it up there, and people can decide for themselves, who they want to follow or not follow.
I would throw my computers and devices out the window if
Yeah, I
that was the
wouldn't
case.
use
I
it,
would,
right?
yeah, I mean, it would
Well,
be terrible.
I want to riff on that to talk about some future scenarios that we might have in mind now. No technology talk would be complete without blockchain, right?
Oh, stop. Every conference, literally the answer is not blockchain.
I've got to get going.
I'm
Listen,
just
this
laying
is
that
not-
down.
This is not
No.
actionable investment advice.
There are future blockchain-based social networks where you can't remove content, right? Somebody could post it and it's going to be there forever. There's no corporation to ask to take it down. It's distributed across the world, and it would be mathematically impossible to remove content. So if it's coming, it might be coming. You might be aware that you could solve this problem right now, sprinkle your magic legislative dust on this problem, and the bad actors go right over to this other place where things are uncensorable. So that means challenges to the existence or utility of defamation law. That means that revenge porn, once up, is permanently up and can't be taken down again. So there's a whole world out there that could emerge and can't really be altered that I can imagine. So we should think about all the expectations and all the law that emerged in the past might be deeply challenged by future technology.
Okay, so 230 emerged in the past. Big change. I think the people who say things are very different now, I think that's a completely valid point, and I think looking at what what's happening now and whether this law needs to be formed, perfectly valid. I don't think anyone's an absolutist. But keeping in mind the downsides that you've mentioned of getting this sort of wrong, that it's been wildly successful. People say, what can government do? Well, this is something government did. It seemed to have worked out really well. Don't want to screw it up. So being very careful, I think, about reforms. What do those reforms look like? And we can just sort of go down the line right here. So how would you go about reforming Section 230? And feel free to comment on each other's reforms.
And you can absolutely throw tomatoes at me, just figuratively, not literally. How's that? I think we should preserve Section 230, but it shouldn't be a free pass. That is, Section 230C1, we should make it conditional. That is, we're not going to treat an interactive service, we're not going to treat online service providers as publishers or speakers if they engage in reasonable content moderation practices, right? And that's not looking at any given decision. It is looking at their practices writ large. The premise of 230, let's go back to the original purpose, was to incentivize self-monitoring. We should go back to that purpose and condition the immunity on engaging in reasonable content moderation practices in the face of known illegality. And it's a proposal that I have the language at the ready. Ben Wittes and I have offered it. I've been talking to a bunch of different Senate offices. Maybe they'll be interested.
So that
it would
in
literally
practice, what would that do?
What it would do, it would mean that you get to enjoy Section 230 immunity, but it would not let the revenge pornographers off the hook, right? The sites that engage in no content moderation, knowing that there's deepfake sex videos on the site. So if you do nothing in the face of known illegality and mischief, then you shouldn't enjoy the immunity from liability. You haven't earned it. But I would say the Facebooks, the Twitters, They have extensive speech rules. They have extensive speech moderation practices with staff of, I think there are like 30,000 people at Facebook at this point. They're engaged in reasonable content moderation practices. It would depend on the type of speech. Like if we're talking about non-consensual pornography, what's reasonable is different from what's reasonable for threats and defamation. Maybe a hash program that Facebook is increasingly engaged in is a really good idea, but hashing content and using AI for threats is impossible, because threats, how we know it's a threat, it's contextual, right? Stalking is as well. Stalking is not one of those things that's inherently illegal. You gotta look at the whole picture and context. And so what's reasonable in one content and approach, what reasonableness would do is incentivize experimentation and moving with the times and with the technologies.
And is there a moderation at scale issue with that proposal, though? I mean,
Yes,
it's a lot
it
of,
would
it seems like it'd be really
reasonable
hard.
Content but it's aimed at not any specific decision vis-a-vis content, but at scale, the speech rules and practices and design. So it's looking at a company's approach to content moderation, the design of the site, how they writ large respond to certain types of speech and problems, known problems. And so the idea is to look at it, how are they doing it at scale? And what's reasonable for Yelp, what's reasonable for Facebook is certainly different from what's reasonable from Jim's. Can we revive your blog for a second?
Sure.
Yeah,
WashingtonWatch.com.
There we go.
There's nothing there.
And my old blog, Concurring Opinions, like what was reasonable for 5 law profs running Concurring Opinions 10 years ago, we had like something like 300 commenters on any given day, is different if we were the Volokh conspiracy when it was doing its thing, it had thousands of commentators. So and there were like 6 people running it. So it would matter the size of the company, who was participating in it, what kind of activity they were hosting, reasonableness, the idea of the premise of it, it's tailored to the circumstances.
You think these are reasonable reforms?
So, well, it's about reasonableness, but I share the concern about some of the bad actors. I mean, there are some bad actors that we need to figure out how to solve the problem of them. But my concern about a reasonableness standard, and this comes from having practiced cybersecurity law where a lot of the regulations just come down to reasonableness, is the lack of certainty as to what would be reasonable when ultimately there could be federal appellate judges who perhaps don't necessarily understand the technology.
Could we ever have specific rules for cybersecurity? They would get outmoded in 5 seconds.
Well, but we do. We have standard.
Right?
We have NIST standards, and we have some state laws that have
But
incorporated
they're broad,
the NIST standards.
they're standards.
But they
they're
give some.
broad.
But they give some controls, and they give specific controls. And I think that without any certainty at all, just having reasonableness, and when you're conditioning other people's speech on this reasonableness, that's what I struggle with having just reasonableness for Section 230. I wonder how much of the free speech benefit there would be, and perhaps we don't want that, but I do really worry about the lack of certainty if you just have reasonableness. I think in other areas of the law isn't speech that's dependent on it, but for this there is. So that's what I would that would be my concern with just having reasonableness.
So reasonableness is really hard to administer, but it's probably the only thing to do. The problem is that you've got this legislation in place that has this language, and you've got a Congress that you can't rely on to do the careful little cut and pruning. So my solution
Very skeptical,
is
very
to,
cynical.
You think, yeah, cynical. I've been here a couple of years. My solution is to go back in time, not have Section 230 and just let common law development up to today. And you'd have
Yeah,
the
you'd have
closest thing we
reasonableness.
can
I mean, we'd
approximate
have
to
negligence,
reasonableness.
right, Jim? I mean, in that world, reasonableness would be so litigated, we'd have negligence claims, right?
I think we'd actually know better what was reasonable than we do now, because we've had a flat rule against liability, and it's been mostly
Right.
people getting booted out of court.
Cannot go back in time.
And you can't go back in time.
And I have that DeLorean.
So we have this piece of legislation.
No time
I
machine.
don't trust Congress to change it. And you do have courts, as Professor Citron has pointed out, you do have courts hemming back on it in places, back to, pure publisher type protections on liability, and not where a site is kind of in the business of procuring trafficking or whatever it may be. So yes, reasonableness, but the immediate proposal I have is to keep 230 in place and let judicial opinions continue to work over the law.
And let the companies continue to
Absolutely.
innovate and iterate. This often comes up before we get to Jeff, but why can't we just give people, let people just post on these sites, but let people handle the filters? And why can't there be just more filters that here's the kind of content I like to see, and that's all I will see? That seems like
I built that on WashingtonWatch.com. You could blank out other users. You could blank out particular words.
Why doesn't that happen with these platforms today? Why isn't there just a lot more tools available to people?
I don't know.
They have some block lists, like Twitter enables at least
very
APIs with block
crude,
lists.
right.
Yeah, no, I think they should do better on that.
What about any reforms you're interested
Yeah, so I have two. One is a fairly specific one and one's broader. The specific one is, I think a lot of the sites that I think we're all concerned about, I don't think should be entitled to Section 230 protections. The problem is Section 230 is often decided at a very early stage, so there's no discovery to determine whether the platform has contributed to the development of the content, in which case it doesn't receive Section 230 protections. So I'd like to see some sort of standard where in cases where the judge believes there's reasonable cause that the platform has contributed to the content, to allow limited discovery on that issue. We do that for personal jurisdiction. I think that would be a way to go after the bad actors that never should be getting protected by Section 230, while still preserving protections for the sites that really are not contributing to the material. So that's one thing. The second is, I hear from people on all sides about various issues with 230, ranging from there shouldn't be any moderation to there shouldn't be any protection at all, and they should be moderating everything. And this is all anecdotal, and it's all, I have this specific story. We do not have good empirical evidence, and it is such an important issue. It affects the speech of everyone in the United States, essentially, and the ability to receive information. And so I would like to see a commission, a congressionally created commission, to really gather a good factual basis for this before even proposing specific solutions, because we don't have that right now. And I'm really worried when I hear all these different stories which are really opposed to one another, and that I don't know whether any of the solutions will actually pass, but I would like to get a much better factual record before we make any decisions on what to do with platforms or 230.
What is upside, downside risk? What is sort of the upside of smart legislation, and what is sort of the downside of getting it wrong? Again, you've seen, I don't think there's any debate that Section 230 has been one of the real legislative foundations of the entire internet economy, obviously handled with care. So what is what's the upside of getting these reforms right? What does the internet look like, and what is sort of the downside of just, boy, we got it wrong? What does this all look like? So a little speculation, whoever wants to take a crack at either of those.
Look, the upside is that if we crafted it well, right, I think if we conditioned the immunity on reasonable content moderation practices, or denied really bad actors the ability to enjoy that immunity, we'd have a lot more speech online, right? We would not have stalking, harassment, and threats and non-consensual pornography, which drives people offline. And more often, those people are women and people from marginalized communities. So there is an upside. There's actually a speech upside.
Any other upsides, or are there just downsides of getting it wrong? How could it be better?
I see far more downsides than upsides to any changes, literally, and because of the practical problem of getting through Congress. I just don't trust Congress to do. We could craft something brilliant. The four of us up here, or all the folks in the room, we get together and we could put together perfect legislative history and send it down the street, and what we get back might be something radically different. So I would be very hesitant to open up 230 to Congress right now.
The decisions are being made by lawyers. I assume there are a number of lawyers in this room.
Yes.
We're all risk-averse people. And so decisions about moderation have to at least get cleared by the lawyers. And you see what happened after the sex trafficking amendment. Craigslist, days before it was signed into law, got rid of its personal section because they said, it's just too much risk. And that's going to, I think changes to Section 230, and we might decide it's a
Were
good
you
thing.
surprised at that outcome?
No,
Yeah.
no. I
Yeah,
think
Well, we worked on it, like
Yeah,
with
I'm-
different offices.
and-
It was depressing what came out of the sausage factory. We tried.
Yeah,
what comes out of committee was depressing, and what was signed was depressing.
I testified in the House Judiciary
Yeah.
Committee in support of a limited exception for intentionally facilitating sex trafficking. What ended up, it's a standard that is not, you really can't comprehend it. So the lawyers basically will just be risk averse. So I think that I'm definitely not opposed to Section 230 changes. I just think they need to be really, really carefully crafted and deliberate, and not just sort of some legislative compromise that gets attached to an appropriations bill right before the December recess. That's not what we want.
That's everything these
And
days.
Yes, exactly.
And that's, so Foster and Sester is Jim's proof of concept. Your worry, Jim, is Foster and
It's
Sester.
been validated
No, and
already, yeah.
I'm a Pollyanna, so I'm always engaged and happy to help offices. So I'm not going to give up on the enterprise, but that Foster and Sester is what you're talking about.
I'm going to ask one more question, and then I want to take that for them, of the great panel, then I'm going to ask questions, so whether you're a Pollyanna, pessimist, be prepared. I think we'll bring mics around. So I want to question, if 230 was eliminated, what does that world look like? Do we still have these platforms? Does it destroy their business models? Is it something radically different? Is it just what does that world look like if we did real harm in the effort of reforming to this provision?
So I don't think we know for sure, because for the entire modern internet, we've had Section 230. So there are a bunch of different outcomes. Platforms could take the approach that, okay, well, the common law and First Amendment give me more protections if I don't do any moderation, which I think most of us would say that's not a great outcome. They could also become risk averse and just say, we're not going to allow user content because that just exposes us to too much risk. Or perhaps it'll be somewhere in between. But I can't say with any certainty what would happen, because that would really be new territory for us.
And perhaps because you would have thrown your computer out the window.
Yes,
as you mentioned.
exactly.
So you would just not know what was going
Exactly.
on on the internet.
Brett Skorup and Jennifer Huddleston at the Mercatus Center have a good article on the common law developments that they saw coming along when 230 was passed. A trend, because publishing has changed, a trend toward treating platforms as conduits that aren't and can't be responsible for what appears on their sites. So that gives me confidence that the long-term outcome, I know it's debatable, but it gives me confidence that the long-term outcome would probably be good. We'd get a good result where the economically efficient and free speech protective result would pertain. But in the short term, there'd be a stampede against the platforms of litigation. If the repeal of 230 were to signal that the federal law is opposed to protections for liability, then that could actually undercut the proper common law development. So I don't know how you get there from here. But if you ask the question in the abstract, what happens if 230 goes away? I think common law and First Amendment protections for platforms would arrive at about the place where 230 has gotten, perhaps with some narrow tweaks, so that the worst examples of egregious behavior that's supported by platforms would be impinged upon and would go away. So,
Okay. Thoughts, or should we go to questions? We'll go to questions. Fantastic. All right. If you have a question, raise your hand, and we will send a mic over to you. We'll start with that table right there. Gentleman with the laptop. If you care to say where you're from, feel free.
Yeah, Carl Szabo with NetChoice. James, you asked about the value of Section 230. Mike Masnick actually has a really good paper that came out. $440 billion over the next decade is the value. You asked about content moderation. We actually at NetChoice have a report coming out shortly that aggregates all the transparency reports from Facebook, Google, and Twitter. They removed in 6 months 5 billion accounts and posts. So there is active content moderation. But I did want to hit on something that you brought up at the end. What happens if we get rid of Section 230? And Section 230, Jeff, you point out in your book, goes to encourage content moderation. 8chan doesn't really matter if they lose Section 230, right? Because they don't engage in content moderation. Danielle, you brought up Grindr, which seems to not engage in a lot of content moderation. Do you expect to see a rise in hate and offensive and terrorist content as platforms move away from the risky content moderation towards well, we achieve total immunity if we do nothing?
That's just not true, though. They don't risk it by engaging in content moderation. You're saying if we change Section 230. Is that, oh, so sorry. I just wanted to make sure I understood the premise of the question. We wipe out Section 230, you're saying. And then we wipe out Section 230 and we live in a world which, Prodigy, we're afraid of being treated as publishers. And so we engage in no moderation, content moderation. And I think that's in part what Quinta Dresic and I worried about in a paper that we wrote about FOSS and SESTA, that we would have either both bad, Scylla and Charybdis, of no moderation or too much moderation. So I share your concern, right, that we're going to end up looking like either 8chan, it's like the Wild West, or then it's family friendly, then it's just overly censored. Just what we thought 25 whatever years ago.
Do you all, I'm jumping back. I mean, do you think that a lot of these companies would just love to be out of this business? They would be love to be out of. They would love to be out of the figuring out what's hate speech, what's not hate speech.
Oh yeah, they would like Europe off their backs, but that's not because of us. Does that make sense? Like the hate speech conversation, that is because of Europe. Truly, that pressure is less coming from.
But I would also just say that they'd love to be out of this business, but they need to be in this business.
Yeah, well,
This is a product and a service they're making a lot of money off of. They need this is part of the job.
It should be said at least once in this event that the users out there are a little bit responsible too.
Yeah.
We're crazy.
When it comes to fake
Totally.
news,
Nuts.
whatever happened to don't believe everything you read, right?
Oh,
and
man, it's a
and
fun one.
Another,
turn it off and
another
put it down
question.
and-
On that side, you're very quiet over there. I'll come back to you.
Cognitively removed.
Back table right there, right next to Mike. How convenient.
My name is Roger Cochetti, and during the 1990s, I was the IBM executive responsible for worldwide internet policy, and thus had a front row seat in the development of Section 230. There was an important piece of the puzzle the panel hasn't discussed, and it leads me to think of what might be a blunderbuss way to deal with the issue. One of the elements that went into the assumptions that we all made at that time was that the future would be very much like the past. And most of us had in mind, at the time 230 was approved, computer bulletin boards. That's what we thought of as content. Now, how could a poor, and someday the thinking was that someday there would be 100 million people on the internet and there would be 100,000 websites. And everyone really assumed that there would be Facebook in the future. In fact, there would be thousands of Facebooks, and none of them would have more than like 2% market share. And everyone assumed there would be a Google in the future. In fact, there would be hundreds of Googles, and none of them would have more than 1% market share. There would be a distributed system like the internet itself is distributed. So there was never any expectation of enormity that we see today.
And your question, sir?
And the question is, perhaps that assumption that went into thinking about, and because of that, it was assumed that the internet was going to be made up of thousands of small businesses that could never possibly monitor 100 million people posting on their bulletin boards. The question then is, if we, and I realize this is a blunderbuss solution, but think about it for a moment. Suppose we went as far as to say any network that has 1 billion users or a market value of $1 trillion is by definition a publisher with the same rights and duty to care that the Northwest Current and the Georgetowner Today have when they post want ads, or they have to look at it and make a judgment. And at that scale, you are a publisher, and no gray area. You have the same responsibility that a call-in radio program or or a neighborhood newspaper has of duty of care when you reach that size.
All right, we want to
think,
jump in
Joe?
on that one?
No, Joe?
I might think too abstractly about most things, but I have a hard time thinking that justice changes. The terms of justice in the world change if the size of your network goes above 999,999,999. So I want the rules to be rooted in justice and not administrative stuff that keeps the lawyers working. Either you're doing it right or you're doing it wrong. There's reasonable and there's unreasonable, and the law should hew as closely as possible to that. Not you got to be reasonable once you reach a certain threshold of users or market capitalization or whatever the case may be. So that type of rule exists all over the place, and you see lots of small businesses staying small so they don't have to provide health insurance to their employees, and I don't want more of that. Not in this area.
All right, unless you want to add something. Gentleman right here, right in front of me.
Good morning. Thank you for doing this. I'm Jeff Jarvis from the Newmark School of Journalism at CUNY. And I'm also a member of a, pardon for the long title, Transatlantic Working Group on Content Moderation and Freedom of Expression, organized by Susan Ness, sitting two people to the left of me. And I've learned a lot at that group. So I want to just throw two quick ideas out to get your response. One from that group that I've learned is that maybe we should concentrate not on content, but on behaviors. You're trying to get rid of behaviors, and that's what law does. And there's a suggestion coming from one member of the group that there ought to be national internet courts, where matters of legality should go to a court where we negotiate legal norms in public with due process. And in terms of the legal but irritating, which is what the UK wants to go after, now we have Facebook's oversight board, where they're trying to establish that, and we'll see how that goes. So I wonder about your views of these kinds of efforts to, in essence, come up with new common law through different paths as we negotiate this very new landscape.
Danielle, you've written about this quite a bit.
Yeah,
so,
no, in 2014, in my book, Hate Crimes in Cyberspace, I argue that that companies should engage in what I call in a different venue, technological due process, that they should be transparent and accountable for their content moderation practices. That is, it could be as a matter of law, but that they should. And I'm not sure if I see, and maybe Jonathan can join me on this, the difference, conduct and speech, the line's really blurry. And so the difference between content and conduct, yes, it's true. I think we should be more careful to realize that some speech actually is tantamount to conduct in that stalking, harassment, workplace sexual harassment. There are some moments where we can say, that's truly like a bludgeon, an instrument, rather than, conveying a message or viewpoint. But largely it's really hard. So I'm not sure if that would be, I feel like I have my speech friends with me here. That would be, conduct and speech are one and the same. I'm going to channel Kitty McKinnon here a little bit. Like a lot of conduct is expressive and vice versa.
Yeah, but I don't want to talk about that.
No, you
I'm
talk
interested
about
in
what you
the-
want to talk about. Yeah.
A national internet
Right.
court
Oh, yeah.
sounds like a thing you'll get if you just wait around for a couple of years and the older judges move out and the younger judges move in. So I don't know about a specialized court for this. And I actually want to challenge, because you mentioned it a second time now, the idea that companies should be providing due process and transparency. I'm a big fan of transparency.
And not because they're
in
state
the governmental
actions,
context,
but just
right.
that we could require them.
But true transparency in your content moderation would be a huge gift to your adversary. Because over on 4chan, or is it 8chan now? I'm a fuddy-duddy. I think of 4chan. They would go and figure out how to game the rules
but
you've
just
just published
say,
and
we
do the
can't
thing that
game
falls
us.
right on the
That's-
line between the
That's
two.
nonsense. No.
It is not nonsense. They
It's
work
nonsense.
hard.
Of
Smart
course.
people, unfortunate, socially
But
maladapted.
platforms are smart too. You
people
can't game us.
working very hard to game published rules. That's a gift, I think, to
That's law.
to them.
So you're saying
Right.
we shouldn't have law that's published and we can game?
No, but it's gameable, and you have to have laws that that don't have too many nooks and crannies because people will game them rather than just live right.
So I would say there has to be more transparency than there is right now. And we're getting better. I think today compared to 3 or 4 years ago, there is much more transparency, but we have a long way to go. And this is one thing that I really stress to the tech companies is that Section 230 is not a constitutional right. This is something that Congress has provided, and there are some people who will say Section 230 isn't a benefit to the tech companies, and I think that's nonsense. Of course it's a benefit to the tech companies. It's a benefit to the public as well for free speech platforms, but tech companies do receive, they've been able to structure business models around this, and I have no problem with some sort of transparency basically being a premise of Section 230 because we need to have a better idea of what's going on. We haven't, and now you see what's going on now with the debate, which is chaotic. So
When you say transparency, so when someone, an account gets suspended, it's not a mystery. You're like, oh, that makes sense. I get why that happened. And the person could have that kind of expectation if they engage in that behavior. They will understand that's a likely result.
I think that, and I think that could maybe help improve user behavior than it, compared to where it is now, but also more transparency about the broader policies. I mean, the platforms have policies posted, but they're fairly broad, and I think getting more specificity as to how the decisions are made, I see that as being a benefit overall.
Shorter and clearer policies. Group over here, reluctant to ask a question, but then now one straight, as I'm sort of rudely pointing with my red pen right there.
Elizabeth Banker, I'm with Internet Association. I have a question about Professor Citron's proposal. As many commentators have noted, one of the advantages of Section 230 is that it does allow companies that are sued to get rid of the cases fairly quickly through a motion to dismiss, asserting the 230 immunity. It sounds like your proposal would require litigation before being able to get to that stage. Yep. And I'm just wondering about the impact on smaller companies. We did talk about how, without Section 230, the bigger companies would have the resources to do more litigation, while smaller companies wouldn't necessarily have the same resources. So is there a way that your idea kind of takes into account that smaller business impact?
So reasonableness itself would. What is reasonable is different from the small, but it doesn't address your excellent point about the cost of litigation, right? That what's reasonable, we can adjudicate, and it would be very different from what's reasonable for small than versus big, right? And it's true that there would be costs. At the same time, we shouldn't forget that there are costs of the current system where there's no expense. There is dismissals, and what happens is we lose a lot. We lose a lot in terms of speech of victims who go offline. We have a lot of harm that is now externalized and borne only by individuals and not by the revenge porn operator. So I guess what I would say is I recognize that would be true, would be more challenging and expensive for the small company to face litigation than it would Facebook. And even if it cashes out, that you have less onerous rules for small than big, that there would be the expense, of course. You might have more censorship, creep, and collateral censorship for the small versus the big, because they can't litigate. At the same time, some of those small actors are the folks running revenge porn sites. And so I think we can't overlook that there are meaningful trade-offs, and it's not all trade-offs in speech in one direction, which is just that poor provider. Right. There's also a lot of trade-offs for victims who, without any change, they will be driven offline.
Excellent. There's another question over here. Maybe a gentleman right directly.
Hi, thank you. I just wanted to pry into something Jim brought up at the end that I think is a really important point, and I was wondering kind of what the panel would think about. The question posed at today's event is, should we reform Section 230? And I think that there's two halves to that, right? We have our academic question of, well, is there possible ways that 230 can be improved? And then there's the other side, which is, should we kick off that process here in DC and in Congress? And I think there seems to be, complete agreement on the panel that 230 has been very beneficial is very important to the internet that we all enjoy today. So my fairly quick question is, with Congress not necessarily being trusted with a lot of tech policy or even policy more generally to get things through in a way that really gives us what we want, would you kick off that process? Would you take that risk that potentially Congress could undermine Section 230 fatally just to get through potentially reforms that you see as beneficial?
I mean, we have Article 1, which pretty much says they have to. I mean, they're the ones who are charged with it, and I think looking at it is one thing. I mean, one of the jobs of Congress is to look at the laws that they've passed. So I think I would agree there are some challenges that Congress has with understanding technology, and I'll just be as broad as possible in saying that, but that's not a reason to not look at laws. I think there are efforts to revive OTA, for example, which would help inform that and is absolutely essential
The
when
Office
we're
of
dealing.
Technology
Yes,
Assessment.
yeah, which basically was Congress's in-house technology think tank, and that sort of thing. So yeah, I think Congress has to look at laws. Whether they should do anything is something different. I'd like my commission to help inform that. But yeah, I mean, we have no other choice.
Your question, I think, helps show that we're kind of talking about two different types of governmental bodies. Do we trust the legislature or do we trust the judiciary more? The talk of the common law is over on the judiciary side. It might be handled better there. No question that the world of litigation could be reformed quite a bit itself. So the costs that the earlier questioner referred to are serious and not to be forgotten. Maybe familiarity breeds contempt, but I worked in Congress and I've been a Congress watcher for a lot of years, and I don't think I would try to run anything through there. We're much better off keeping 230 where it is and letting case by case perhaps trim it back where appropriate.
We have time for only one more question. It needs to be concise, powerful. So if you're going to raise your hand, if you raise your hand, there's going to be a huge, okay, so
Flasher.
right back, this is a biggie. Wait for the mic.
Wait for the mic.
Yep.
Everybody needs to hear you.
Will Duffield, Cato Institute. These private moderation systems that these platforms manage are essentially private legal systems. And in order for them to work, to get buy-in, they need to be legitimate in someone's eyes. In whose eyes should they attempt to legitimate themselves? Users, states, the population at large? What renders these private governance systems legitimate or not?
The market.
Yeah.
Cato Institute. I had to tee that right up.
Crazy response.
Did you not know the answer to that
No,
question?
but the question allows me to put an important gloss on what I said about transparency. Transparency, I do think, would be a gift to people who are trying to game your system. But if transparency will give your users and your governmental overseers confidence that what you're doing is right, then okay, go ahead. But you're going to have problems with your adversaries because of that transparency too.
All right, I would think that will have to be it. All-star panel, all-star audience. Thank you very much for coming.